Mr. Ubis.
Mr. Chief Justice, and may it please the court. The government agrees that when a defendant voluntarily ceases conduct challenged in litigation, it has a heavy burden to make absolutely clear that the conduct could not reasonably be expected to recur. But the court right declaration just promises Mr. Fikre that he won't be put back on the no-fly list based on currently available information. That's inadequate for three reasons. First, if our client was previously listed for attending the wrong mosque and attends that same mosque this year, the declaration would allow the government to relist him. It gets worse. Even if he doesn't attend again, but the government gets new, suspicion-inducing information, not about Jonas, but about the mosque itself, the declaration likewise allows the government to relist. Any new fact not currently known to the government would allow Jonas to be relisted, consistent with the declaration. And if he is relisted in either of those ways, that's recurrence of the challenged conduct. He is disadvantaged in the same fundamental way his complaint was meant to redress. Imagine if Nike had promised already not to bring any trademark claim based on currently available information, but could sue for infringement based on new information. Under those facts, the court couldn't have concluded that already could move on with its business free from suit. Second, the court right declaration does nothing to guarantee Fikre notice or a hearing if he is relisted, and therefore does not address his procedural due process claim at all. The government's response is that he has no current plans to relist him, but the government insists on retaining the right to do so, and that's its prerogative. But if it does relist him, there's 100% certainty that his procedural claim will recur. Third, because the government hasn't disclosed either to Jonas or a court why he was listed, a court can't possibly say anything clearly at all about whether recurrence is reasonably likely or not. And Mr. Fikre cannot move on with his life in the way the lawsuit was meant to allow. He doesn't know why he was listed. He doesn't know what might cause him to be relisted. He doesn't know if the next time he worships at a mosque or travels abroad, he might be relisted, massively disrupting his life once again. Mr. Fikre is peaceful, a law-abiding U.S. citizen. He has a live controversy against the government and seeks only to litigate that case on the merits. That's it. I welcome the court's questions.
How would the government's declaration have to be amended in order to satisfy your notion of mootness?
Yes, Your Honor. For the substantive due process claim, if the government submitted a declaration, either to us or to the court itself, disclosing the reasons, and made a promise that matched up with those reasons, not to repeat them or invoke them or similar ones to them, we think that that could moot the substantive due process claim. For the procedural due process claim, if the government described, okay, we didn't have notice, now there's notice. You didn't have a meaningful opportunity to rebut the evidence against you, now here's a meaningful opportunity to rebut the evidence against you. In doing that, they would be able to moot the procedural due process claim.
So you actually, you want repudiation then?
No, Your Honor, we don't believe that repudiation is required. We don't think that the Ninth Circuit required repudiation. What we do, what we do is we agree with the government. The repudiation is one kind of evidence that shows that the likelihood of recurrence is lower. And here, the evidence is not neutral. The government didn't take no position on its past conduct. They doubled down, and so that counts against the government in meeting its burden.